Thanks, Shona, and welcome to part two of this year's Corporate Insolvency Legal Update. In today's session, we're going to take a deep dive into a topic which is always of great interest, and that's the approval of an IP's remuneration and the role and remit of the court reporter. Now, this is a topic which, as most of you will know, has seen a great deal of scrutiny by the courts over the years, and it's one which we've covered extensively here on the Legal Update. And after a flurry of court decisions a few years ago, we had entered a relative period of stability on the topic. So it was probably inevitable that we were due the court taking a fresh look at matters. And the latest decision on this topic is the opinion of Lord Braid from April of this year in the petition by the former administrators of Future Renewables Eco plc for an order to fix their remuneration and outlays. A decision which I think it's safe to say has been one of the most pored over both by IPs and lawyers of the last year, so very deserving of a legal update deep dive. Now, there's quite a complex background to the company and its affairs, which we don't need to get into. Suffice for today's purposes to say the following. Prior to the administration, the company had engaged Interpath to carry out some work with a view to trying to avoid a formal insolvency. That plan didn't work, and Interpath were then appointed as administrators by the directors of the company in September 2021. However, they were then replaced as administrators by Begbie's trainer a couple of months later in November. The former administrators, the petitioners, then sought to have their remuneration and outlays fixed, ultimately applying to the court, who remitted matters to a reporter in the usual way. Now, in terms of the sums being claimed by the petitioners, they were seeking remuneration of just over £302,000, of which around £70,000 related to a 5-month period after they'd been replaced as administrators. And they were also seeking outlays of nearly £94,000, of which around £71,000 was in respect of legal fees. And after having considered matters, the reporter approved the outlays in full, but recommended a reduction to the remuneration. Now, the petitioners were content with that and lodged a motion for approval of the reduced sum. However, that was opposed by the new administrators, the respondents, who raised various objections, asserting that the remuneration and outlays claimed were excessive and didn't fairly represent the value of the petitioner's work to the company, particularly, but not exclusively, in relation to the sum sought for that 5-month period after the petitioners had left office, which, even after the recommended reduction, still amounted to £57,000. Now, before getting into the specific objections raised by the respondents, there are two general points and takeaways from this decision to note. Firstly, on locus, the court confirmed that the respondents, as the current administrators, did have locus to oppose the petition and object to the remuneration and outlays being claimed. It was argued by the petitioners that the respondents didn't have locus, in part for reason that there isn't a specific provision in the rules or the Act, which specifically states that the current administrator can challenge a former administrator's claim. However, the court confirmed that there doesn't need to be a specific provision in the rules. Instead, the common law entitles anyone who can demonstrate title and interest to object to a petition, and as the respondents were the current administrators, they clearly had title and interest. The second point and takeaway relates to the status of the reporter's advice. Lord Braid's view was that the reporter's report was simply one factor, albeit an important one carrying considerable weight to be taken into account by the court in reaching its own decision as to the appropriate level of remuneration and outlays. He did, however, accept that the court must give cogent and justifiable reasons if the reporter's advice is not followed by the court. So a reiteration there that the ultimate decision is one for the court. Now, with all that in mind, what were the specific objections in this case? Well, there were 4 in total, and they were in respect to the following. Firstly, the outlays claimed by the petitioners, and in particular, their claim in respect of the legal fees incurred by them. Secondly, the relevance of the pre-appointment work and costs. Thirdly, the post-appointment costs, i.e. the cost claimed for that 5-month period after the petitioners had left office. And finally, costs in respect or arising in relation to the petitioner's refusal to hand over certain files to the respondents. And I'll go through each objection in turn. Firstly, the outlays, and specifically the legal fees. Now, as a starting point, the 2018 rules, it's Rule 3.951C1 to be precise, provide that an administrator is entitled to claim for any outlays reasonably incurred by them. And SIP 9, which is the Statement of Insolvency Practice dealing with the payment of outlays, divides outlays and expenses into those that don't need approval before being charged to the estate, known as Category 1 expenses, and those that do need approval before being paid, known as Category 2 expenses. And with that in mind, the reporter's approach to the legal fees being claimed was to correctly note that in terms of SIP 9, they were a Category 1 expense, which meant that they could be paid without prior approval. As such, and as the petitioners themselves had agreed that these fees were reasonable and correctly vouched, the reporter went on to conclude that the correct approval process had been followed and that the outlays were now due to be paid. The points in dispute here, however, were whether the reporter should have made inquiry into whether these outlays had been reasonably incurred and whether or not there was also a need for the court to approve these outlays. The petitioners argued that there wasn't, and that as officers of the court, they were the final arbiters of whether or not these costs were reasonable, and that in terms of SIP 9, there was no need for the court to approve these Category 1 expenses. The judge, however, disagreed. His view was that an administrator does require to seek the approval of either of the creditors or the court for outlays reasonably incurred, including Category 1 expenses, and that meant that the reporter should have considered whether these outlays had been reasonably incurred. And by not doing so, the judge said that the reporter had fallen into error. Now, in coming to this view, the judge said that SIP 9 was simply a statement of practice issued by the regulators with no statutory effect, and that it can't therefore trump the rules, but that nor does it purport to do so, as it merely states that a Category 1 expense can be paid without prior approval. And that is, of course, right. In addition, the judge also made the point that for the legal fees to be chargeable to the administration, they not only had to be reasonably incurred, but also had to be reasonable as between the petitioners and the law firm. And it was only if the fees passed both tests that they could be charged to the administration. And in the circumstance of this case, particularly given the sums involved, the judge ordered the legal fees to be taxed. So how do we draw all of this together? Well, my takeaways from the judge's decision on this point are this. As per SIP 9, Category 1 expenses can be paid from the estate without prior approval, but Category 1 expenses do still eventually require to be approved by the creditors or the court, who will require to consider, firstly, whether the expenses are reasonable as between the administrators and the third party, which may involve, in the case of legal fees, considering whether the fees have been or should be taxed, and secondly, whether they were reasonably incurred. Paying Category 1 expenses in advance of that approval would therefore seem to carry with it the risk, as in fairness it always has, that the creditors of the court take issue during the approval process with whether those expenses have been reasonably incurred. That said, on speaking with several IPs in light of this decision, it's a risk which is accepted in practice, as the practical reality is that most outlays require to be paid as and when they're incurred, and it's simply not feasible to hold off paying them until the creditors or the court have approved them under the rules. As the recent ICAS briefing note on this decision has noted, while none of this is new or changes what the legal position on approval of outlays was, what this decision has done is shine a light on inconsistent practice in relation to outlays, whether that be by court reporters, those applying for remuneration and outlays, and, it has to be said, by the courts themselves and how they set out their determinations. The second objection related to the relevance of the pre-appointment work which had been carried out by the petitioners for the company prior to the administration. Now, the reporter wasn't asked to consider that work. His remit was, of course, only in relation to the post-appointment period, and as such, he wasn't provided with any information about the work which had been carried out pre-appointment. But it was the fact that he wasn't provided with that information which was the basis for this objection. How could the reporter properly form a view as to whether all of the post-appointment work was reasonably done and provided value without being privy to details of the work done pre-appointment? In other words, this objection seemed to relate to the fact that there may have been charges made for work in the administration which had already been done and paid for as part of the pre-appointment work. Now, the petitioner's position was that there was no need to provide information about that pre-admin work, and in fact, that work might have resulted in less work needing to be done in the administration itself and therefore have resulted in a cost saving. However, the judge's position was that neither the reporter nor the court could be satisfied in any of that unless details were provided of the work done pre-administration. He therefore concluded that through no fault of his, the reporter's inquiries were incomplete on this point and that further inquiry ought to be made by him. The takeaway from this element of the decision would therefore appear to be this: where work has been done by an IP or their firm pre-appointment, the court does consider that to be a relevant matter for inquiry by the reporter. The third objection concerned the post-appointment costs, and in particular, the claim by the petitioners for the 5-month period after they'd been replaced as administrators, where they were claiming around £70,000. Now, it was accepted by the court that the affairs of the company were complicated and that some work would, of course, be required to effect a handover to new administrators. But the court's view was that it was hard to envisage how even the reporter's reduced sum of £57,000 for this period could have added value to the administration. And he concluded that there needed to be more detail and explanation on these costs. He said that the breakdown of the time costs for this period lacked detail and raised as many questions as it answered. In particular, he pointed to the time entry for fees and WIP, 56.8 hours at a cost of £30,000, and questioned what that related to. Now, the reporter had commented on this entry, noting that the majority of that time related to the preparation of the documentation for the reporter, time which was, in the reporter's view, excessive. However, the issue which Lord Braid still had with this was that it wasn't clear just how much of the reporter's overall reduction related to that figure, and the court needed to know precisely how much of that £30,000 had been disallowed by the reporter. In his view, the reporter had also not given adequate consideration to the extent to which this post-admin work had provided value, and therefore, with all that in mind, he considered that the reporter required to give further consideration to this post-appointment work and costs. Now, the takeaway from this element of the decision would appear to be this: a reporter should explain in sufficient detail the process by which they arrive at their proposed reductions, and should specify the particular items which they consider to be excessive and to what extent. More generally, reporters should also consider the extent to which the work claimed for provided value. Although I would pause there to question what exactly value means in this context and how easily that can be assessed by reporters. The test articulated in earlier case law was about the work needing to be necessary and appropriate, and that would seem to be a far better and easier to apply formulation of what a reporter should be considering when looking at work claimed for. But nonetheless, Lord Braid does appear to consider value to be an important consideration. Finally, on this objection, the judge did also make an interesting comment, which I'm sure will raise the eyebrows of everyone watching, when he questioned whether any time spent in preparing the documentation to justify the fee charged was properly chargeable against the administration. Now, while he didn't answer his own rhetorical question, it's clear from the decision that it's something which he's given thought to. Now, clearly, work which requires to be carried out by the IP in compliance with a legal requirement or obligation, whether that be under the Act, the rules, or as a consequence of a court decision such as this, clarifying the level of detail to be provided by IPs, should all, in my view, be properly chargeable to the state. So it'll be certainly be interesting to see if this is a point which is revisited by Lord Braid in the future. The final objection and issue related to whether or not the petitioners were entitled to charge and claim for work which they had not made available to the new administrators. Now, the issue here wasn't whether the petitioners were right or wrong in withholding particular items of work, but rather the court said whether they were entitled to charge for work for which the company and the new administrators were unable to benefit because they couldn't see it or use it. He said that the new administrators may require to undertake the same work again, and he therefore questions why the company should have to bear the costs of the work being carried out twice. Ultimately, the judge said this also required further consideration, and he asked the reporters to identify how much of the sum claimed related to the items in dispute, and to consider whether the work done had provided a benefit to the company for which the petitioners were entitled to be paid. And perhaps the takeaway from this objection, at least in this stage in the proceedings, is this: if a claim is made for work, the benefit of which has not been made available to the replacement office holder, then there's a risk that the court may decide that you're not entitled to be paid for it. So those were the 4 objections, and for all the reasons we just discussed, the judge remitted the case back to the reporter and to the auditor for specific consideration of those issues. The judge also made some further observations about the role of the reporter and the level of detail required in a report. The judge reiterated that although the reporter's function is to advise the court on whether the remuneration and outlays are reasonable, it's the court which must make the ultimate decision. As such, the court must be provided with sufficient detail to enable it to make that decision. And it was with that in mind that the judge considered that the report in this case didn't provide sufficient detail, as the court needs to know not simply the total of the reductions, but which particular items are considered to be excessive and to what extent. He also made comment on the standard practice of the reporter informing the IP of a proposed fee reduction in advance of issuing their report. The judge does say that he doesn't know whether or not that's normal practice where a reporter is proposing a reduction, but he's clear in his view that where the fee is contentious and there's an opposing party, he doesn't consider that's appropriate to do so. He said it's one thing to seek clarification on a point of detail, quite another to suggest a fee to one party and not the other. It's not a reporter's function to negotiate a fee, rather it's to give advice to the court. Now, I think this is an unfair criticism for a number of reasons. Firstly, there's no suggestion that the reporter was negotiating a fee as the judge implies, and clearly that wouldn't be appropriate. Secondly, I understand that the reporter here was unaware that there was an opposing party. Indeed, how would a reporter know that in advance? And finally, the reporter was simply following the ICAS court reporter checklist as well as the ICAS style report, as a quote there on the slide. The takeaway here, however, seems to be that where a fee is known or suspected to be contentious and there is an opposing party, the court doesn't consider it appropriate for a reporter to contact the IP to discuss any proposed fee reduction. At the very least, a reporter will need to ensure that any contact with the IP can't be construed as a negotiation. So it'll be interesting to see if ICAS issue further guidance on this point or whether the judge himself reflects on this point in due course, because, as I say, this is both standard and regulator recommended practice. As the judge himself states at the end of his opinion, this matter as a whole will doubtless come back before him following the further reports from the reporter and the auditor. So I suspect that we may well be revisiting this decision in a future legal update. But in the meantime, that's it for this year. Thank you for watching, and back to you, Shona.